But going by the last week's history of the Supreme Court, I don't think it's going to be very honorable. Thank you.
Not on. It's not on. It's not on. इसका volume adjust कर दो.
I must say, I have to point out something. You are absolutely right. I did not say that, and I did not say what exactly has happened or has been happening. We have 11 cases against us, 3 criminal, 8 civil. Most of them in Ahmedabad, 2 of them in Bangalore. I have to go to Ahmedabad reasonably regularly. I must also say Ahmedabad is an extremely boring city, so it's not a matter of great pleasure. But I purposely, we have taken a call not to talk about our issues at all, not even hint about it, not even, kind of suggest anything. That's just a call we have taken. It's just to be a little careful. That's it. Thank you.
I'm really glad that Siddharth kicked this off, because he's talking about whether we talk about it as online media, which is what he does now, or whether we talk about it as print or television, which is what most of us grew up with. That's called mainstream media. And he then mentioned the other side of it, which is social media. And social media is what we used to do when we sat in a, at a cafe or a restaurant or on the roadside and chatted. That was social media. But now that social media is something that actually has a scope for reaching a lot of people. So I want to talk about that aspect of freedom of expression. Because he said, very rightly, that when you say this newspaper is not presenting a good picture, then what you need to say is, okay, there's another newspaper which is presenting a good picture. But what if you can't say either thing? Because you're too frightened to say it. You're not frightened to say it anymore on the roadside when you're chatting with your friends, although that's also a problem. You're frightened to say it in the new form that has become available to all of us. You're frightened to put it on your telephone, and you're frightened to put it, on your computer, because you're frightened about who will actually see this. You're frightened about what the reaction to that will be. And that actually happened yesterday. You must have seen, day before yesterday, the news about a chap called Kenneth Sequeira in Goa, who was arrested by the police for some Facebook post which hinted about the illness of Manohar Parek, who happens to be ill. His post was only about the illness. Okay? We don't even know what that post is, because that post is not available anymore. But he was arrested for not taking down the post. Not for any denial or discussion on that post. He was arrested for not taking action in removing the post. Okay? And you'll be glad to know that he's got bail, which is quite a positive step. That means he's actually not in jail anymore for not taking down a post. But anyway, who am I to be talking about all of this? Thanks to Mihir's help, I'm actually sitting in the court myself because I'm one of the people, together with my friend Dr. Nagarjuna, who's actually opposing the introduction of an identity scheme. And this identity scheme has been promoted as something that is, the next best thing since mother's milk. It's supposed to make sure that welfare is delivered to everyone who needs it and who's entitled to it, on the premise that a lot of that welfare is not going to people whom it should be going to. This goes back famously to a statement made by Rajiv Gandhi that where he was actually quoting a foreign NGO to say that very little of the money that people donate for welfare actually reaches the people whom it's supposed to. So we get into a situation where the government is actually delivering some of this welfare. And why is the government delivering this welfare? Because we are a constitutional democracy. And we have a constitution which tells us that we're supposed to make this country equal. That's in the constitution, that we recognize that we have problems with that equality, and therefore it is directed upon us to do the kind of things that are necessary to make the inequalities go away. So then why am I in court? Why am I, who've got absolutely nothing to do with, my whole life, nothing to do with courts and news, why do I feel so upset about it? That I think that this is not the right way. Because, as it happens, and this was actually news to me, when we actually went to court, I was under the impression that all of us were entitled to our privacy. It took discussions with lawyers to discover that when it's not written down in the Constitution, then certain elements, and some of them being in the government at the time, took it upon themselves to believe that we were not, in fact, entitled to our privacy. So what is the impact of not being able to have assurance of your own privacy? What has that got to do with the discussion over here, which is about freedom of expression? And the reality is it has everything to do with it. Because if you are not able to express your opinion with a sense that it is confined to the people you intended it to be discussed with, if you then discover that actually other interests have access to the content, to the things you are speaking about, then inevitably you will feel frightened to talk about it. You will say, well, I feel that way, but I won't say it. I won't tell my best friend because somebody else's ears are also listening in. And why does that happen? It's because this so-called identity scheme has actually been created to link just about everything that you could possibly imagine. You discover your insurance is linked, your bank accounts are linked, and all these things that are linked are no longer pieces of paper. In the old days, they were pieces of paper. So going through them to discover these expressions of dissent was a hell of a job. Today, it's not a hell of a job if you have access to them. Now, you have companies whose business it is to trawl through masses of data, and masses of data of truly phenomenal size. It's their business to trawl through it and say, oh, look at this group of people, they think this way, and guess what, we can drill down in that group of people and we can come up with individuals who actually think that way. So guess what, here's a nice weapon, stamp them down. And why do you think there's a worry that you might be stamped down? Because we have a history which tells us that yes, there have been times in the past when people did stand up to say something and got hammered down. And the last time an identification scheme was used for this purpose was, of course, I think all of you know it, was in Nazi Germany in the 30s and 40s, when an identification scheme was used to separate dissenters and people of a particular religion from others in the same population, and not just in one country, but across dozens of countries. And they were stamped out thoroughly. as they say, with extreme prejudice. Could that happen in India? Well, of course it could happen in India. It happened in the China War. We did it ourselves. We took all the people of Chinese descent and we put them in concentration camps. That's us. That's not some other people who did it. That's us who did it. So if it could have been done in the China War, do you think it couldn't be done today? Very much so. So as it happens, I brought some notes over here, which were something that we came to know through this journey through the courts. And the case that we filed actually was in fact drafted by Mihir over here. But a couple of years after it was filed and we were failing to get any hearings, to our shock and surprise, it was grabbed away from Bombay and taken to Delhi by a Supreme Court order, which was not conveyed to us. And it was not conveyed to the court. But it got done, because that's the way it operates. That's the way the system works. The Supreme Court forgot to inform the Bombay High Court that they were not supposed to listen to our case, and they were supposed to send it to Delhi. And then the people we filed a suit against, the UIDAI, kindly informed us one day before the last day that, by the way, if you don't have any objections, your case is being sent off to the Supreme Court. Literally, one day before the last day. So that's what happened, and it went off to the Supreme Court, and that naturally put us in trouble, because guess what, we're just ordinary Bombay people. We don't have any connections in Delhi, and we don't have any, we don't have any skin in the game in Delhi. So we were actually floored by this, and we didn't know what to do, but really it's touching and very positive that so many people gather around to help, and they found us lawyers, and they found us support, and we have a very good Supreme Court lawyer now who's been fighting our case very passionately in Delhi, and really put together a very, very good defense. And the two hearings that have happened so far, one hearing was about privacy itself, and as you know, that was a resounding judgment last August, where it was affirmed that yes, there may be no such word in the Constitution, but there is a very good reason for there not being any such word, and it doesn't matter because it is implicit in the Constitution that we have always had privacy. It is a guarantee for us. And the reason it is a guarantee for us is because with privacy, you have the ability to express yourself. You have the guarantee that you can express yourself, your opinion will remain private to the people that you want it to be, that you meant to share it with, and that there can be no consequence to that breach of privacy, which is otherwise called the panopticon. And the panopticon was an expression which was created about 150 years ago, when a very eminent jurist named Jeremy Bentham put together this concept that you could have a prison where all the glass in the prison was one-way glass. So the guards could see you and the guards could hear you, but you would never know when the guards could see you or hear you. And that chilling description of a prison 150 years ago is very much a reality today, because you don't need glass anymore. It's your own phones that are talking. It's your own computers that are talking. And that conversation is being picked up and used, can be used against you with no warning. The only warning and the only protection you have is the law. That's the difference between a functioning nation of free people and a dictatorship or a monarchy or all the other forms that we've seen through the years, and we decided that wasn't good enough for us. That 70 years ago we decided that we had to have a democracy, and that we would have a democracy of free people. People who would be free, and part of that freedom is freedom of expression. The ability to express yourself freely to whom you want, to whom you trust, and not have it misused or abused by turning it against you. So one of the things that was put forward very strongly in the Supreme Court was that this digital world can be used as a panopticon. And there's a good reason why it should not happen like that. Well, we've seen now, that was last August, and since last August we've discovered some of the tools that are being used in social media. Some of the very commonly platforms, you might say, that's the common term used for them, platform. So Facebook is a platform. That the data you shared on Facebook with your friends and your choices you made as to what kinds of friends you wanted to have, you now discover that Facebook's definition of friends wasn't quite what you thought. And Facebook's idea of what could be shared wasn't quite what you thought. And shockingly, you discover that the government of India has no interest in protecting you from Facebook. Because Facebook misunderstood or used its own interpretations of what your freedoms are. And the government of India, instead of protecting you from that, instead of saying, Facebook, this is what you can do in India and this is what you can't do in India. They've never said that. Till today, they've never said that. Because guess what? They don't even see it as their duty. It took, a very powerful judgment last August to tell them, hey, everyone in this country is free and everyone has the right to privacy. Instead, astonishingly enough, you have government lawyers arguing in the Supreme Court, and the hearing is going on now, as you must be aware. It's going on every week for sometimes 1 day, sometimes 2 days, sometimes 3 days a week. We have constant hearings on the legality of UID. I really dislike using the brand name, but you probably all know the brand name. It's Aadhaar, okay? And we are totally against the fact that it has been branded. That sort of makes it acceptable, because now it's like Bata shoes. And Bata shoes are acceptable. But Aadhaar is not acceptable. And some of us are quite against the use of the term, because Aadhaar in Hindi actually means foundation. And this is not a foundation. This is the very opposite of foundation. We like to use the word Niradhar. This is disgusting. The use of common terms to persuade you that your logic and your common sense are not good enough. Please, some big shot with a lot of money has come up with a brand name, and therefore it must be good. This is a common thing, you say, oh, let me go and buy that shirt, it's from this good brand name. Therefore the quality must be good. But when you see a brand name for an identity scheme, you say, oh, it's got a brand name. It's all very subtle in your mind. Oh, it's got a brand name, it must be good. These are subtle kind of ways in which you are persuaded that things that are not good are actually good. Which is why several of us in this fight against the scheme are against the very idea of using a brand name for it. When you say it's got a foundation, you think, oh, they said it's an identity scheme. No, they never said it was an identity scheme. They said it was an identification scheme. On what basis is it supposed to be identification? On the basis of biometrics. What's the science of biometrics? There is no science of biometrics. None. What is the origin of the confusion of the term to be used for biometrics? A French policeman, scientist, forceful personality named Bertillon decided that biometrics could be used 100 years ago to catch criminals. His system was thoroughly discredited. It was found to be a miserable failure. But here we have it today, after that miserable failure, where we found that biometrics didn't actually narrow down on criminals with perfection. You could not be sure that you could be able to narrow down on criminals, when that system was thoroughly discredited, you find it coming back in new forms. Why? Because people can make money out of it. It's really very easy to do in the digital world. You get a biometric thing that works for, by their own admission, 88% of people. That's the Supreme Court submission by UIDA. Perfection for 88% of people. But by the way, when you say perfection for 88% of people, it means miserable failure for 12% of people. 12% is more than 1/10 of the country. That should give people pause. It should give people some sense of horror. What is being done to us and why are we accepting this as truth? But the problem is that if you can't express this doubt openly, then sooner or later you end up behaving as though your mouths have been taped over. And then there is no difference between being locked in a jail in a panopticon and living in a free society, because you're not living in a free society. So that's really what we need to worry about over here.
Thanks. After I finish, I guess we'll go for a round of comments and questions both. We began the meeting with a 2-minute silence for Justice Sachar. I would treat that also as a 2-minute silence for the second death of Justice Loya, which happened just 2 days back. I will be basically talking about dissent, the whole question of use of laws to curb dissent. In the last few years, remember one thing, that our constitution gives us freedom of speech and expression, the right to protest, the right to organize, right to assemble peaceably. All these fundamental rights are given by the constitution. But as the Supreme Court says, that actually they are not given by the constitution, they are only recognized by the constitution. These rights already inherit us, freedom of speech, expression. Constitution only recognizes it. Even if tomorrow Constitution takes it away, these rights remain with us as human beings. Constitution doesn't create these rights. Constitution recognizes them. They are so important. In a democracy, dissent is bound to happen for any thriving democracy. Dissent has to happen. There are bound to be differences of opinion. There are bound to be two views or multiple views on various issues. Even in a normal, happy society,